Hi, it's Shan Wu with a under color of law hot take on the controversy over Justice Samuel Alito flying not one, but two flags that are associated with support and unity with those who stormed the Capitol on January 6th. On May 16th, the New York Times reported that only 13 days before the inauguration of President Biden in 2020, Justice Alito's house in Alexandria, Virginia, which has a flagpole, was displaying an upside-down American flag. Now, that's a symbol which has been adopted by Trump supporters contesting the Biden victory, and it flew on the justice's front lawn even as the Supreme Court was considering an election case. That flag and others like it were carried into the Capitol as it was stormed on January 6th. So Alito defended this display at his house by saying that it was his wife's fault. He said he had no knowledge of her displaying this flag and that it only was up there because there had been a dispute with a neighbor. Neighbor had supposedly put up an anti-Trump sign in the yard. Alito later told his favorite network, Fox News, that it was more than just an anti-Trump sign that had caused the fight. There had been a verbal confrontation with a neighbor who had insulted his wife, Mrs. Alito. Now, one thing to think about here is that why might there be a conflict of interest? And before we even get into the slightly deeper analysis, let's just think about this. Let's take the justice at his word for a moment. He had a confrontation with a neighbor, maybe a really nasty neighbor, who insulted his wife, called her names. Now, if that same matter, let's say the police came, arrested the guy, if that neighbor was before the justice, would there be a conflict of interest? I think so. He'd have a view on that. And the fact that he calls that sign personally insulting, that's what he said, indicates that he has a strong feeling about this matter of anti-Trump signs. So if he has a strong feeling about that, it would make sense that he should be considering getting out of cases involving pro-Trump people. So that's something to consider. Now, there have already been many calls for Alito to recuse himself from any cases involving January 6th and Trump, particularly the presidential immunity case that's still pending before the Supreme Court, and which the Supreme Court has very conveniently taken so long to issue an opinion that it's almost completely wiped out the possibility of any Jack Smith prosecution getting on track to be tried or resolved before the presidential election. Now, here is a take from one judicial ethics expert on this matter. So let's take a listen.
On point, 28 U.S.C. section 455 that says whenever a judge's impartiality might reasonably be questioned, that's the key phrase. Whenever the judge's impartiality might reasonably be questioned, they shall, mandatory language, disqualify. In the case of Clarence Thomas ruling on January 6th and 2020 election-related cases, it's a slam dunk. It's unequivocal. He absolutely has to recuse, but he has not. Unfortunately, his refusal to do so has created a kind of quasi-precedent that creates cover for the closer call scenarios like we have with Justice Alito. Will Justice Alito recuse? No, he will not.
So this judicial ethics expert points out something really important. There's already a federal statute in existence that can apply to the justices, because we hear a lot of talk about how it's all up to them to recuse. There's nothing we can do about it. Not really true. 28 U.S.C. section 455 is something which is completely ignored by most conservatives. And it reads disqualification of justice, judge, or magistrate judge. Subsection A, any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. Now, a little bit of sexist wording, I guess, can only apply to male judges, but it should be for any gender of judge. That is a very broad standard. It's a reasonableness standard. And it would require recusal in cases like this. It's not discretionary. Of course, it will also apply to Justice Clarence Thomas's refusal to recuse himself, even though his wife is literally a witness in the January 6th insurrection matter. However, listen to the anchor's reaction to this idea that there should be recusal of Alito.
Choice 3, which is take him at face value, that some neighbor puts up an F Trump sign at a school bus stop and then calls her the C word, and this was the response, without regard for embracing and endorsing what transpired on January 6th. You get the final word.
Well, with the benefit of 2020 hindsight, that reaction has not aged very well, because the New York Times recently revealed that a second politically symbolic flag had also been displayed at one of Justice Alito's houses, this time at his beach house. This was not an upside-down flag. It is a flag which is often known as the Appeal to Heaven flag, which also, like the upside-down flag, was carried by the rioters into the Capitol on January 6th. Originally known as a pine tree flag, it actually dates back as a flag to the American Revolutionary War. It too has been adopted as a symbol of support for those who support President Trump and claim that the whole election was stolen. In particular, there's an aspect of this flag which is more of a religious aspect. And there is a whole very extreme religious group that very much wants to push for a remake of the American government in Christian terms and supports Trump, which has used this particular flag. And that's been reported by the New York Times. Now, it's unclear exactly how long the flag was flying at the Summer House, but there were multiple photographs obtained by the New York Times from different people. They're independent photographs. It's not the same person snapping the same photographs. There are also accounts from people who had passed by the house and neighbors, and they even did a Google street image and found the map on there. So sometimes in July and September of 2020, that flag was being flown there quite visibly. So there really is not a factual question as to whether the flag was flown. Now, this time around, Justice Alito has not commented. He didn't even blame his wife for this one. And of course, the Supreme Court has not commented either. Nothing surprising there. So in the aftermath of these two incidents, we are going to hear the usual comments from conservatives who will be saying that this is all a unfair attack on Supreme Court justices. We heard Mitch McConnell talking about how the Supreme Court should be left alone. Kind of rich coming from the guy who did not leave the Supreme Court alone, who actually prevented Merrick Garland from becoming a Supreme Court justice by refusing to have any vote on Garland. Just imagine, if only, right? So McConnell was quoted as saying we should leave the Supreme Court alone. One other conservative commentator has said, and this is a very common theme among the conservatives when they defend actions. That commentator said, Alito's just a fan of U.S. history. He really cares about U.S. history. And that's wrong to make historical symbols, which may now be embraced by the right, into symbols of hate. Because after all, it's just history. Now, what does that sound like? It kind of reminds me of why the South wanted to put up Confederate statues after they lost the war during the Reconstruction. All of a sudden, these Confederate statues starts going up. Why? Just because they loved U.S. history, right? Now, there's also going to be the usual paralysis with the left calling for recusal, which the justices won't do. Recusal is simply up to a judge or a justice, and it does happen a lot. Justices on the Supreme Court will say they're not going to hear this case, and they don't even have to give reasons. Usually it can be figured out. They might have some interest financially in the company. Maybe they once worked on the case in some other capacity. But really, it's not totally uncommon, and it's really up to an honor code system for a judge or justice to recuse themselves. The right will simply say that, this is all political to even ask them to recuse, and altogether, nothing is likely to happen. Importantly, everyone talks about it as though we're all helpless. There are really no tools upon which we can rely upon, given that recusal is voluntary. But I want to point out that's wrong. There are tools that our system of government is supposed to use. The system is supposed to be a balance of power. Remember? There's the legislative branch, the executive branch, the judiciary branch, and all three have tools that can be used. So let's start with the judiciary itself. Chief Justice Roberts is actually the head of the federal judicial system, and he was quick to announce that there would be an investigation when that Dobbs draft was leaked. Now, it was a very weak investigation conducted by the Supreme Court marshals, which really have no experience or capability of doing an investigation. But nonetheless, he announced an investigation. And certainly, at least that much could be announced with regard to these flags being flown, not to mention the Clarence Thomas and Ginny Thomas issue, his wife, who is the witness and was an active supporter of wanting to overturn and not recognize the legitimate vote, not to mention all of the money that financially benefits, perhaps not actual cash, that has been given to Thomas and Alito in the forms of trips, vacations, luxury vehicles, and the like. Why not announce an internal investigation inquiry into that? Also, there is the tool of the leadership of a chief judge or chief justice. A chief judge or chief justice can exert a lot of leverage in talking to more junior judges or justices, perhaps encouraging them to recuse themselves in situations where they're kind of going off the rails or it's a bad look for the court. But Roberts, despite his reputation as being very dedicated to protecting the institution of the Supreme Court, he's very concerned with the image of the court. But the court has reached its lowest public confidence levels in modern times. He really doesn't seem capable of doing anything on an internal basis to rein in these kinds of rogue practices that are being publicized primarily by excellent investigative journalism. It's not like the justices themselves, revealed this. Oh yeah, there was a Supreme Court Code of Ethics that was finally adopted by the justices after decades in which they were the only judges in the entire country that had no code of ethics. State judges, other federal judges all had a code of ethics, but not the United States Supreme Court. However, that code of ethics has been pointed out and criticized by numerous commentators and legal scholars as being, first, a very obtuse legal document, and it's just chock full of loopholes. It's basically still a self-policing code that they put out to kind of stem some of the tide of bad publicity that they've been getting. So that's the judiciary. Sounds a little bit helpless, but there are things they could do, such as doing an internal investigation about these issues. Then there's the legislature. Congressional oversight could require that the justices come to oversight hearings, and they could be subpoenaed to talk about these issues. What did you mean by putting up that flag, Justice Alito? Why didn't you disclose, Justice Thomas, these financial benefits you were getting? That's what Congress does. They conduct hearings. They ask people to testify under oath about what happened. Congress also has, of course, the power of the purse. They could actually impose the equivalent of economic sanctions upon the court for failing to enforce its own ethics code, or for maybe failing to come and testify to Congress. They could withhold funding. They could cut funding. There's a lot of power when you're controlling the money. Particularly, they could reference that statute we talked about, 28 U.S.C. Section 455, which calls for disqualification, not recusal. Disqualification is an affirmative disqualifying, can't play, versus recusal, I'm not going to play. One's voluntary, the other is not. And that statute is particularly important because it specifically mentions justices. So there's no question that it applies to them. The Supreme Court has long taken the view that while for lower federal judges, inferior ones, a judicial ethics code does apply to them, but it doesn't apply to them because they are the Supreme Court justices. This law, however, on its face, does apply to them. And then lastly, totally overlooked in the usual discussion, is what can the executive branch do? Meaning, what can the Justice Department do? And there's actually a lot DOJ can do. They can open an investigation on a number of fronts. It doesn't have to be criminal. You can have civil investigations. And it could even, for example, look into the leak of the Dobbs opinion. They do leak investigations all the time. They could also scrutinize the question of what kinds of benefits have been given to the justices. Are there any concerns about the lack of disclosure they were supposed to disclose on their financial disclosure forms? Again, it doesn't have to go criminal, but I mean, it could if you were to find that there's actual corruption involved with the financial benefits. There could also be tax issues. These were very expensive trips. That luxury vehicle, Thomas Scott, cost a lot of money. So there could be a tax inquiry. Was it properly declared by somebody as a gift? Is it really income? Again, merely opening this kind of investigation doesn't mean that they're prosecuting the justices or even accusing them of wrongdoing, but it is an inquiry. It's something that they can investigate. And really, just announcing such an investigation, letting it be known that they weren't afraid to do it, even if they appointed a special counsel to do it, would go a long way towards making people feel more confident that there is oversight. Now, they don't need a special counsel, Lord knows, because there's nothing wrong with DOJ investigating judges. They do it all the time. Lots of judges have been criminally prosecuted for corruption. That happens. Some of them even been impeached. So they could do that. They could even produce a report if necessary. They could follow the money and prosecute if it was warranted. But again, just letting it be known that the executive branch through DOJ was actually doing something to look at the justices would restore confidence that judges too can be held accountable. It's really, to me, the real weak link has been DOJ here. Congress has made some noise about trying to do oversight. There's even been some legislation that's preliminarily started about reforming the Supreme Court. And you have a lot of judicial ethics experts talking about the judiciary. The third branch, the executive, has really been missing in action here. And they really need to weigh in here because they're part of the checks and balances. Judiciary doesn't look like it can do much. Congress could do more, but DOJ has done nothing. So justices are justices on the Supreme Court, not supreme beings. They simply sit on the highest court in the land, and we have the tools to police them the same as any other citizen, the same as any other institution can be policed. And it's long past the time that we demanded that our institutions do that. So I recently wrote an opinion piece in the Daily Beast in which I noted something about this appeal to heaven phrase on the flag that Alito had flown at his beach house. So that phrase originated with a 17th century thinker, the philosopher John Locke. And Locke was writing about the responsibility to rebel, even use violence to overthrow unjust rule. And as explained in the New York Times piece by a historian, that phrase is really meant to be, quote, a paraphrase for trial by arms. You might remember some of the phrases that were used on January 6th, where Giuliani, I believe it was, who said, trial by combat. There's a reason why this sort of phrase has been used with this flag, making it into a symbol. It really means that there is no other appeal. No one else you can ask for help or judgment. You take matters into your own hands. That's the notion of this appeal to heaven. Now, of course, it can be used in perhaps more sympathetic conditions. We might agree historically with certain kinds of rebellions that happened, even the American Revolution, where the flag originated from. But the importance of symbols is that they are adopted by people and beliefs for symbols. So the fact that this is a symbol which has been adopted by insurrectionists, people seeking to challenge and overthrow the government, that's important. And questions need to be asked and answered about why the justice, who is supposedly a fan of history, knowing this, it was not accidental, oops, I didn't realize the flag meant that. Questions need to be asked. Why? Why was he flying it? Why did he fly two symbols like this? The phrase also reminds me of the Chinese philosophical concept, the mandate of heaven. And that's very ancient. It originated in the Zhou dynasty, 1046 to 256 BCE. And that phrase was used to justify revolutions and rebellions against dynasties when circumstances such as famine and flood indicated that the emperors had lost the favor of heaven. They lost the mandate of heaven. And so today, our society and government, we treat Supreme Court justices less like members of the highest court and more like higher beings, immune from any normal constraints. And so in that way, they do resemble emperors. And we would do well to remember what the ancient Chinese knew from experience. Emperors can fall out of favor. And the Supreme Court should realize that because they're well on that path. So that's it for now. I'm Shan Wu, and I really enjoy hearing from you. Love the comments. It's really helpful in thinking about what to address next and how to address it. So talk to you soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.